Good afternoon, everybody. Welcome to today's webinar. I am Mike Fielding at the law firm of Husch Blackwell. Joining with me is my law partner, Chris Miles, and we're going to be talking about our quarterly review of commercial and ag lending disputes, really talking about noteworthy cases that have happened in the past 3 to 4 months. So before we begin, I know we have a few people still logging on. I am going to read through these housekeeping matters, and we'll jump into the program. So first off, if you have any questions during the webcast, please submit them via the question box. You'll see it there on your console. We will try to answer all the questions during the webcast today, but if a fuller answer is needed, we'll follow up with you via email, or if we run out of time, that occasionally happens as well. A PDF presentation of the program is available in the program materials folder. The program, for those of you that are attorneys, my condolences, but this program has been approved for legal education and HR hours. For live attendees, you report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And then finally, toward the end of the program, we will have a short survey. We would ask, if you don't mind, to give your feedback on the survey. We really look at that. We really like the feedback and the guidance that's given, because we try to tailor this and do the programs in a way that's actually truly valuable for you. So without further ado, let's get started. And let me just give a kind of a brief background. So both Chris and I, we represent lenders, secured lenders. Need to emphasize that, represent secured lenders in commercial and ag related disputes. Chris and I work pretty closely together. And one of the things that I've been doing really now for half a year is every single day I get various reports of new cases from around the country. And I read through those kind of summaries and I identify, like, oh, this is a good case, that's a good case. And then I put them in a pile. And then towards the end of the quarter, I then essentially go through them and do quick little summaries. But to make it interesting, we put these in quiz formats just to get it a little bit engaging. We don't do polls because we're not into shaming, right, if you happen to get the answer wrong. But we are interested in trying to be educational here. So without further ado, let's get started, all right? So question number one. This is kind of a boring one, but we'll start this off the bat here as people still logging in. So question number one, you had some borrowers, they sell cattle out of trust, the lender sues, alleging the conversion of the collateral. The borrowers file for bankruptcy. Lender sues on a non-dischargeability complaint against the borrowers, and they ultimately reach a settlement. And as part of that global settlement, the lender agrees to release its UCC lien, except to the extent needed to prosecute a conversion claim, because there was a third party involved with the cattle. The third party, the lender then goes after the third party. The third party says, hey, you settled your case, you released your UCC, therefore no conversion. The question is, by entering into the settlement agreement, did the lender extinguish its conversion claim against this third party? What say ye? All right, pause, let's move on. So the answer is no, the claim was not extinguished. The settlement agreement was worded, and you'll see that in the question that I put there, it was worded in a way that the UCC filing was preserved to the extent needed to pursue the conversion claim. So you can see that the plaintiff here was a farm credit out of Minnesota pursuing the claim, and they were smart, frankly, in the way they drafted the agreement. So what's the takeaways? What are the lessons that we can learn as we're dealing with borrowers? Well, the wording of settlement agreements is extremely important, and when you are dealing with situations where you have multi-parties involved in a transaction, you need to be really careful that if you settle with just a few of the parties, you need to think through and say, how is this settlement agreement going to impact my ability to pursue the non-settling parties? The most common example, I think, is maybe you sued a borrower and maybe you're working with 2 or 3 guarantors, but there might be 1 or 2 kind of holdout guarantors that are like just trying to get the free ride, trying to get out and just get out of the whole situation. Guarantees are maybe not the best example, because most guarantees I've seen they have broad waiver of defenses, but you don't want to, inadvertently create a problem through your settlement agreement that could later impact your claim against, who you're going to pursue. The other key takeaway is the wording in your settlement agreement really matters. I know, especially when you've been fighting on a case and you're like, oh, we reached a settlement. It's like when you're a little kid and you're riding the bike up the hill and you finally get to the top, right? And you're like, oh, we've made it. We can take a breather. Well, I know we have that inclination and we do the settlement agreement, but the problem is that wording of what you actually put into that agreement really matters. And so just because you've reached that agreement in principle, don't feel like you're at the top of the hill. You're actually close, but you still have to kind of ride that bike up a little bit further up the hill. All right, next question. This is a Food Security Act. I know these first two questions are dealing with livestock. We don't have many livestock questions today, but the first two are ag related. So the next question, are thoroughbred horses, quote unquote, farm products within the meaning of the Food Security Act? All right, think to yourself, are they? Well, the answer is it actually depends. And this particular case comes out of Kentucky. So of course it's Kentucky. Maybe some people would say the horse capital of the world, of the US. And in this particular case, the horses were deemed to be livestock or farm products, I should say, under the Food Security Act. And the reason here is that in this particular case, the livestock operation was or involved breeding horses being used by the stable operator. All right. Now, why does this matter? And the answer is it depends. Well, that's a bad answer. The reason is that there are some situations where horses definitely will not constitute farm products under the Food Security Act. And you say, well, why is that? Well, a classic example is, let's say that you have a row crop farmer. Maybe this is a mega row crop farmer, 7,000 acres, right? They're just planting every plot of ground they can see in sight. And then on the side, they have a hobby and they have horses, right? Well, horses are not a cheap hobby. They can be really expensive. You can actually get quite a bit of money into horses. But horses do not constitute farm products in that situation, because the horses are not being used as part of the farming operation, right? The farming operation are the row crop operations. And so in that situation, somebody may, depending on the wording of their security agreement, they may think that they've got a lien in the horses, only to find out later on that they're not. Or you get into a situation of Food Security Act, and if the horses are sold, does your lien attach, et cetera, et cetera. So what's the practical takeaway? What's the moral of the story here? Well, the takeaway is you need to, number one, really understand your borrower's operations, and you need to understand how the livestock are actually being used in the operations. And then two, depending on how they're used, you want to look at both your language in your security agreement and make sure it's drafted in a broad enough way that it's not just like livestock used in farming operations, right? We would think that includes horses, but it may not. But you may want to word it more broadly to include like all animals owned in this. And let me give you another example, two other examples. We live in Missouri, right? Some people would say Missouri is the capital of the puppy mill capital of the world. I don't know if that's true or not, but there are definitely a lot of puppy mills. Well, do they fall into the livestock category or not? You know, you think through this scenario. Another one is there are a lot of exotic animal farms in the state of Missouri. Do these animals fall under this farm products exception? Again, it's depending on how they are being used. Think of Tiger King, right? Some people get all caught up in the drama of that, but from a lender's perspective, you're saying, well, did the lender's lien attach, right? These are questions you want to be thinking about and asking yourself. So, all right, let's move on to the next quiz. Chris?
Thank you, Mike. This is a scenario that most of us never want to see, but it does happen. In this particular case, it's a consumer case where a mortgage lender who'd purchased a bundle of notes went forward with trying to enforce this was a particular note that secured a mortgage, and it moved forward to try to enforce it, and the borrower sued, saying that you don't have the original note, and you don't have a lost note affidavit either in the file, even though that's fairly standard practice. So in this particular case, the borrower sues, and we have to ask, can you in fact enforce this particular mortgage note? And the answer is yes. And from my experience, that's a yes with an asterisk. In this particular case, the facts were such that the new lender, the assignee, was able to provide evidence of the assignment. In my travels, many borrowers will argue that the lost note affidavit, which is very standard in the industry, is some kind of a magical document, that if it's in the file, it will save you when you have a lost note or lost instrument. And if it's not in the file, then you're dead in the water. Well, that's just not the case. What governs this particular area of law is the Uniform Commercial Code, Article 3, and it's Section 3309, which specifically governs the incidence of a lost note. And it doesn't say anything about a lost note affidavit. The lost note affidavit has just become one of those industry standard practices that one uses to prove up the facts that you need in order to enforce under 3309. And very, very quickly, for those of you who need a little refresher or haven't run into this, you basically need to show that at the time of the loss, the party that purported to assign the note or that had the note was in fact the party entitled to enforce, and that the loss was not the result of a transfer or a seizure, which is to say that a lender's lender didn't come in as part of a receivership or something like that, or its own loan enforcement, and take the note. If the loss happens as a result of something like that, then of course it's not enforceable. It's at least by that person. It's probably enforceable by the other lender who used a judicial process to seize it. Likewise, it can't be the result of a transfer, and a transfer has a very specific definition under the code, which is that it was actually transferred from one party to the other as a part of a transaction or a negotiation. So in other words, if Bank A sells the note to Bank B, and then Bank A comes and tries to enforce the note and says, well, we lost it. It's like, well, yes, you did lose it. You lost it in the act of selling it to somebody else. So no, you are not the party who can enforce. Going to the key takeaways. Number one, don't lose it. This is always a huge headache. Even when you have fairly good evidence, you have a person who executes some sort of a lost note affidavit. The fact is that if they did it years ago, any borrower's counsel will be able to most likely, maybe not ultimately successfully, but they may be able to at least avoid summary judgment by demanding that this person who maybe executed a lost note affidavit 10 years ago come out of the woodwork and answer questions about the note. And of course, that person's working at a financial institution where they do this all the time. Their chance of actually remembering that is awfully low. So first thing, don't lose it. And if you do, make sure that the note or the lost note affidavit is prepared very close in time to the loss, so you can provide as much detail as possible. When loans are being purchased, always good to review the file immediately upon receiving it. Most of you have probably seen a collateral file. It's your 8 by 11 and it's got the original blue ink deed of trust, maybe some mortgage insurance documents. If the original note is not in there, the time to call the seller is immediately, not down the line when you think you might need to enforce. And lastly, in this, getting back to the Greer case that we just talked about, they in fact did not have a lost note affidavit, but they were able to prove up the chain of assignment. So I would not recommend relying on that. Best to deal with these things as quickly as possible and prepare notes, lost note affidavits if you can, or ask the previous lender to do so before you purchase it. So moving ahead. This is a particular case in which you had a business being purchased, and you had sort of had a situation where you had hybrid financing, which is to say that part of the sale was financed by the selling business, who took a junior lien position, and then there was a senior lender who helped the new business owner acquire the assets. And the junior and senior lien holder entered into a basically intercreditor agreement, which subordinated the junior lien holder's position and contained a number of provisions that were to the senior lender's advantage, one of which was called a standstill provision. And that basically told the junior lien holder, it doesn't matter if the borrower defaults and stops paying you, you can't initiate any kind of an action. You're basically just going to sit there until we do an enforcement, and then if there's any left over, you'll get paid. It also allowed the borrower to refinance without any leave of the junior lien holder. It allowed additional advances under the loan, and it allowed the senior or the junior lien partner to be terminated upon a sale of collateral. Why the junior lien holder agreed to this, I'm not sure, but they realized sometime later that this was not to their advantage, and went ahead and sued to override those provisions. After the senior lien holder had behaved pretty much as contemplated by the agreement. So who wins? Senior lien holder. The court found that these were two sophisticated parties. They could read the provisions. The junior lien holder knew what it was getting into. The junior lien holder made an interesting argument saying that they were discharged by breach, and what they said were breaches were actually specifically contemplated in the language of the agreement. So the court tossed that out and said, not only would these not be breaches of good faith and fair dealing in normal circumstances, but you specifically signed an agreement that contemplated those actions. So our key takeaways are make sure you read whatever you sign. And if you're the senior lien holder in this particular case, again, if you want to have the right to do something, make sure you spell it out, because the facts were what they were in this case, but you could certainly see if there was loose language and that you had a sympathetic court to the junior lien holder, that might provide them a foothold to override those provisions that had been negotiated by the parties. And I'll turn it back over to Mike.
All right, so let's dive into the world of bankruptcy, or more specifically, how on earth do we prevent a bankruptcy from happening? So this case comes out of Texas, and you had a situation here where the lender, they have a pledge on the equity in the LLC. The lender hasn't foreclosed or taken ownership of that. Loan amounts, it's $4 million, and the loan agreement requires that the LLC amend its organizational documents so that the organization has to get lender's consent before filing for bankruptcy. Sometimes you may have heard the phrase bankruptcy remote entity, or that's the idea here, that we're trying to make an entity so they just can't immediately file for bankruptcy. So the LLC does that. But then the LLC's owner, who is also the LLC's manager, votes to file for bankruptcy and goes ahead and files Chapter 11. So the lender comes in and says, whoa, 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 that's not the deal. You can't do it. Wasn't supposed to do it. Case needs to be dismissed. The question is, who wins here? Does the company stay in bankruptcy or not? Well, the answer is that, whoops, got to click the right button. The LLC wins, all right? And the point here was that the organizational documents had been changed, but the decision to file was done by the manager in his capacity as the manager of the company. They hadn't quite taken care of all the authorities or taken the authority away from the manager to prevent the bankruptcy or prevent the LLC from filing. So the court essentially is on, I guess you could call this a corporate authority decision, says, well, you didn't, cross all your T's or dot all your I's. You did half of it, but not the other half. But then I think the more telling part here is that the court then goes on and says that, we really don't like these blocking provisions. It really seems bad from a public policy standpoint. And they may not be effective if you're trying to prevent a bankruptcy. So, where you're left as a lender, frankly, you're left kind of scratching your head. Can I stop a company from filing for bankruptcy? I will say that my experience is that judges tend to not like that. They're bankruptcy judges, right? That's what they're hired to do. And so anything that keeps cases from getting in front of them, I think they have a judicial inclination to have the cases come in front of them. I mean, I get where the judges are coming from the public policy, which is, that's a right. It's given to companies and people, and you shouldn't be able to prevent them from filing. I would say, especially if you're dealing with an individual. Let's say you had an individual and you tried to get in a forbearance agreement that the individual waives his or her ability to file for personal bankruptcy. I think that would be extremely difficult to try to uphold that or get a court to enforce that. When it comes to individuals, I think the law is pretty strongly in their favor. It's a little bit better if you're dealing with companies, but it's not great. So what do you do? Well, I think you need to realize that if you're getting these blocking provisions or putting these bankruptcy remote provisions into your agreements, they maybe work, maybe even from a psychological perspective, because if the person never attempts to go down that road, then you've won. So there are benefits that way. But if the person does say, well, I realize it's in the agreement, but who cares? I'm still going to try to do it. It may not, be a complete defense. So it's good to know just where things stand on that. Chris, let's take up quiz number 6. Family Feud.
Thank you. So this is a case out of Missouri, a very recent one. You had a husband and wife, had a tract of land. They wanted to deed it to 2 of their 3 children. They went to their local attorney's office, who prepared the documentation and got it backwards. And the deed is later recorded. There's no indication that it was delivered to either child number 3 or child numbers 1 and 2. None of them came with the parents to the attorney's office, and there's no evidence that any of them knew what was happening until much later, when mom discovers the error and comes and asks the child number 3 to agree to reform the deed of trust. Child number 3, the ingrate, says, no, I'm not going to do that. And mom brings an action for reformation of the document. So can this error be reformed? No, it cannot. So pausing here, under Missouri law, it is very difficult to reform a deed of trust. There has to be either mistake or fraud, generally. And there are 2 types of mistake. There's mutual mistake, where both parties make a mistake about some material provision in a document, That's mutual mistake, and that is a basis to go ahead and reform an instrument or a deed of trust. Also with fraud, if a party lies or makes some material misrepresentation about either the transaction itself or the subject of the transaction, then deed of trust can be reformed. Unilateral mistake is harder. The deed of trust could be reformed in this particular case by child number 3, because child number 3 didn't make the mistake. However, because it's a unilateral mistake, i.e. just a mistake on the parent's part, they do not now get to come back and say, well, gosh, we made this mistake and we need to reform the deed of trust. And courts will also look at how significant the reformation action is. So I'll give you a quick example, war story from my own practice. We had a case called Deutsche Bank v. Luna, which went up to the Missouri Court of Appeals, decided last year, in which there were 2 mistakes. One of which was one number in the legal description was incorrect. It should have said 6, instead it said 8, and it had to do with the number of feet of the lot, or of one dimension of the lot. The borrowers did not particularly care that was reformed, and the court seemed very to view that as almost an afterthought. However, the wrong party was on the deed of trust in that case, and there was fraud there, and mutual mistake, and so we prevailed on that one. But it is extraordinarily difficult to get instruments reformed in Missouri. The majority of cases require clear and convincing evidence, which is a little bit of a squishy standard, but it's not as severe as the beyond a reasonable doubt, and it is, but it's definitely more than preponderance of the evidence. So merely marching into court and saying, well, I didn't mean to do that, is not going to get you there. And a few other key takeaways: get title insurance whenever you do a conveyance of land, and before things get recorded or delivered to another party, double, triple check. Always good to spend more time up front than being stuck on the back end like the parties were in this particular case. Mike?
I'll just add one comment there. Where I've seen this come into play too is where the borrower acquires the property from somebody else, from a seller. The lender makes the lien, and then you go 2, 3, 4 years down the road, and then the borrower defaults, and then the borrower contacts us and say, hey, I need you to foreclose. So we can, fine. We go in there, we start getting ready for the foreclosure, and then you realize that there may have been an error, not in the mortgage or deed of trust, which just mirrors the conveyance language, but the error may have been in the conveyance from the seller to your borrower. Again, the title insurance is important, but you just need to be prepared to deal with those issues. All right.
And I have one more, and I'll do one more quick comment. If you are in the consumer area, I have often seen a one page document that is, I can't remember the exact name of it, but it's basically a certificate of cooperation that a borrower signs. And it says that if there are any errors in the loan documents, that the borrower agrees to cooperate to effectuate those and effectuate the intent of the parties. Now, that's not a silver bullet, because in order to get a court to enforce that, you have to use the remedy of specific performance, which is to say you are instructing or you are asking the court to instruct the borrower to not defend themselves in this lawsuit for reformation. And that again, that's better than not having it, but it's also a hurdle.
All right, so let's move on to the next quiz. Number 7, we have 18, so Chris and I need to pick up the pace. All right, we only have 20 more minutes, so speed round time, right? Hopefully you're not dozing off. We're going to pick it up and get a little bit more energetic here. All right, so this next one comes out of South Dakota. Interesting scenario. We're dealing with a loan to a trustee, You can see that the trustee is a secondary beneficiary on this irrevocable spendthrift trust. Trustee wants to get a loan for the trustee's personal use. All right, and the bank gets a copy of the loan documents. The loan is going to be secured by assets of the trust. The bank has its attorneys look at it. They're like, yeah, it looks good. So the lender makes the loan. Of course, there's a default. If there wasn't, we wouldn't be talking about it, right? The lender then seeks to foreclose on the property, but the primary beneficiaries intervene and say, whoa, 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 you can't do that. The question is, who wins? Can the lender foreclose? Well, the answer is no, the lender can't foreclose. And the reason is because the trustee didn't have the authority to mortgage the trust property for his own benefit in the first place. And I think really the compound matters here. Lender knows what's going on, still makes the loan. And the big thing is that the debt is not a debt of the trust. Even though this person is the trustee, he was getting the money for his own personal benefit and using the trust assets to pledge as collateral. So he's, really abusing his position. I would say probably violating his fiduciary obligations. But the bank really messed up here. And so then the question is for you, what are the key takeaways? Well, when you're dealing with trusts, or frankly not even trusts, the big thing I say here on the first bullet point, the person who pledges collateral for loan must have the legal authority to pledge the loan. That's true. I should have also added legal and equitable authority to pledge title for the loan. So like if I wanted to mortgage my house, my wife and I own it, so we could do that if we both agreed to it. If I'm the trustee, I have legal title. It's being held as the trust, but the equitable title is for the beneficiaries, right? And so you need to make sure that if a loan is being made, if the monies are going for the benefit of the beneficiaries, you're good in that situation. But if it's going somewhere else, then you have a problem. Now, I've been talking about this tri-party transaction that it goes way beyond what we'll get into here, but there's an important analogy, which is tri-party transactions when you have the lender and the borrower, but the entity pledging collateral is different from the borrower. And anytime you get a triangular situation, you are potentially, not always, but potentially setting yourself up for an avoidance action later on where somebody could try to challenge the lien in that collateral as being a constructively fraudulent conveyance. So anyway, it's a whole other story for a whole other day, but I just want to alert you to the risk that is out there. All right, Chris, number 8.
Number 8, this is a particular case when you have a borrower who is a construction company. Their senior lender takes a broad lien, including in their accounts receivable. And sometime later, the borrower enters an agreement with a bonding company. And as part of the surety and bond documents, there's some language in there that says all revenues coming from the project which this bond is related to are held in trust for the bonding company. By all accounts, this particular construction company borrower has a general operating account into which its revenues are placed. They eventually default, and the senior lender does a few sweeps, pretty significant sweeps out of that account in order to enforce its secured position in those monies. The bonding company comes back, litigation ensues, and says, those monies were held in trust, your security interest never attached, we have the right to them, and you actually converted our funds. So can this secret trust prime the lender's lien? No, it cannot. The court said that you can't simply add magical language saying, oh, these are held in trust. There has to be something more. The court didn't define all the parameters of that, but it suggested that if you want to have monies held in trust, they need to be in a separate account. They cannot be in a general operating account. Once more, the bonding documents also placed a security interest in those particular funds. So the court was scratching its head saying, well, how can these monies be held in trust for you and yet you hold a security interest in them? that's incoherent, and it looks like you were just trying to jump the line in front of the senior lender by including this trust language. So some key takeaways. This apparently is very common, but it's always a good idea to monitor your borrower's bond agreements to the extent they exist, and confirm that if they are in any of these sorts of transactions, that there is not a separate account into which certain monies are being funneled and held ostensibly for the benefit of the bonding company, because in that particular case, your security interest might not attach and you might not be able to get at those monies. So we'll keep moving here.
Yeah.
Oh, I think we have a question.
Yeah, let's address it really quick. For question 8, would the bonding company not be entitled to the collection of payments from the bonded projects? That's a really good question, and that's where you get into the big fight on those issues. And I've seen it go a couple of ways. I've seen it where the default is called and the bonding company comes out and says we're entitled to this. The problem that the bonding company has is that the bonding company is in a number 2 lien position, and you have the AR on the construction project. And the lender's taken the position that, hey, that's our AR, we're entitled to it. We're in a first lien position. And I think the key thing here is the AR, that is not, that's something in the future. That's a collection that's going to be coming down the road. Now, the bonding company is going to come in and say, well, we're forking out the money. We are completing the job. We're therefore entitled to it. I'm essentially articulating the arguments. I've only scratched on this particular issue a couple times in my career. The most recent one that I recall being involved in is we looked at it and said, yeah, I think in this situation, because the borrower was in bankruptcy as well, we thought the bonding company would be entitled to get the future AR coming in. But again, in the right circumstances, there's a position there for the lender, and you might be able to leverage it to some sort of negotiated compromise. Chris, any other comments before we move on?
Let's move on.
All right, next one, number 9. All right, these next few will be pretty quick. Taxing entity, they have a lien. Now, we're talking about taxing entities, but the principles on this one are going to definitely apply to even if you're a bank. So debtor files Chapter 13, and the taxing entity, somebody messes up. They don't, when they're filling out the proof of claim, they forget to check that it's a secured claim on the proof of claim form. And the Chapter 13 plan doesn't address the lien. And so an argument is made later on. It's like, hey, you filed a proof of claim. You didn't mark the box. The plan didn't address it. Plan's been confirmed. Therefore, waiver, right? You don't have a lien. And the question is, who wins? Does the lien survive? Well, if you know wrong button. If you know your federal rules of bankruptcy procedure, which admittedly not many people do, there's a specific rule there that says, hey, guess what? If the secured lender messes up and doesn't file a secured claim, then they still have their lien. However, they will not be entitled to get distribution during the case. So obviously the moral of this story is, check your proof of claim form when you file it. But if you mess up, guess what? That's baked into the rules to protect lenders. You won't get paid during the plan, but at the end, you still have your lien intact. The other caveat here, and we won't go into detail, but you need to really pay attention to, and it's not just a Chapter 13 plan. It's quite candidly Chapter 11, Chapter 12, or Chapter 13 plan, because when that plan is entered, that's going to have a binding effect on all the parties. And if the plan is monkeying around or doing something with your lien, and if you don't object to it, you're going to be stuck with it for better or for worse. So you always want to really closely review those plans as they come in. All right, Chris, next one.
All right, so we have a 341 meeting. These are standard at the outset of every bankruptcy. Allows the creditor to come in and ask the debtor questions under oath. The trustee also asks questions, goes through the petition and schedules and says, are these accurate to the best of your ability? And any information that's missing or incorrect, the trustee will ask, usually continue the meeting and ask for those documents to be provided in the interim. In this particular case, you had a debtor who gave a number of inconsistent answers in her 341 testimony regarding tax refunds for a number of years. Litigation ensued subsequently, and they wanted to use the 341 audio. I should say that these days, most of these are telephonic, but they're still recorded, and they are available upon request from most trustees at the various bankruptcy courts. And so the question was, could the audio file be introduced in court as a non-hearsay admission against interest by the debtor? And so the debtor's counsel, the debtor had said she felt bombarded, and so she couldn't give good testimony. And then her lawyer tried to keep it out, saying that this recording was hearsay, which, if you recall, is an out of court statement made to prove the matter asserted. Now, I'm sorry, did this go forward?
There you go.
Here we go. Yes, the audio file can be admitted for impeachment purposes because she was giving different testimony in the subsequent litigation. Some key takeaways: 341s are a very valuable tool in a creditor's toolbox. There are really no rules per se, and that's good and bad. Trustees can, if you have too many questions, can abruptly end and say your questioning's over. Or I've had debtors' attorneys, when things are getting a little heated, they'll simply say, we're not going to answer any more questions. And it's awfully hard to convince the trustee to make these people sit in place. But on the flip side, because there are very few rules, you can think very strategically about what questions you want to ask up front and get the most important information out first. And so I'll let Mike take the next one.
Well, yeah, before we go on, let me back up because I want to say some really practical things. Number one, you don't have to hire an attorney to do a 341 meeting of creditors. Creditors themselves can attend those things. The rules specifically allow for that. And I recognize, especially if you're in a consumer situation, you're like, attorneys are costly. Okay, but the good news is you can just have somebody from the bank show up as a creditor representative and ask the questions. All right, so that's point number one. Point number two is sometimes you may feel like these people are just lying through their teeth to you. All right, and there is, again, it's going to be situational specific, but you may want to just ask them the questions and let them lie to their teeth through you because they are doing it under oath, and that has bad legal ramifications. I had a situation like that when I was a young associate. I got up there, a client said, ask about these things. I did. I didn't know the truth, whether or not it was true. The guy responded how he did. And then it was like 2 years later, an attorney from the U.S. Trustee's office came back and said, Mike, do you remember that thing? I'm like, yeah, vaguely. He said, well, when you were asking those questions, that guy was just lying through his teeth to you. I guess he had monies in some other account. Anyway, he ended up getting prosecuted. So that's more of an extreme example, but dialing it back to this situation, if they're lying through their teeth to you, keep in mind that you have other means or remedies in bankruptcy to obtain discovery, and you may want to kind of set them up for a fall later on. I realize I'm belaboring this point, and I realize a lot of times we get really frustrated with debtors who are just absconding and just, getting away with things that they shouldn't. This is a partial means to try to get a little bit of redress in that situation. All right.
Yeah. And just to add one more thing, Mike, this is also a good opportunity. If you can show that they've misbehaved in one little area, and sometimes that's as easy as a couple questions, then you can pique the trustee's interest, at least in the consumer side, consumer chapter 7s and so forth. And that can, the trustee can be a very valuable ally because they have powers that you don't as a creditor. So.
Yeah. It's like when your kid lies to you. Oh, you're lying to me about this. What about these other things? Anyway, saying that I have 6 kids, so I have had to deal with those questions. All right, I need to pick up the pace. So this goes back to our question number 9. Very similar scenario. Auto lender, valid lien, but fails to file the secured claim altogether. Auto lender says, whoa, we're not getting any payments. We don't have adequate protection. We want to get stay relief. Question is, can the auto lender do it? The answer is no, unfortunately not. The court's like, hey, you knew about this. You didn't file your Your lien, yes, you are protected by the rule. Your lien remains intact, but obviously, what good is the lien in a car 3, 4, 5 years down the road? Obviously, that car is going to depreciate quite a bit in value. So the key lessons right here is, and this is super important, there is no grace period in Chapter 13 for late filed claims. I mean, when you see that date, you need to make sure you hit it, because if you don't hit it, you're not getting a payment or a distribution out of that 13 case. So file your claim, make sure you do it right, and then obviously look at the plan like I talked about earlier. All right, Chris, Chapter 12, garnishments in bankruptcy.
You bet. So this is a particular case where you had a physician who had racked up a number of debts from side business deals that had gone wrong. His practice was subject to a number of garnishments in state court. The debtor files for Chapter 11 sub 5 to do a reorg, and these garnishments are still outstanding. And the creditor's attorney says, well, I'm not going to release them just because you filed for bankruptcy, which he should have done. So debtor's counsel, after that, reaches out to the creditor's attorney and says, you need to release these garnishments because the party being garnished, which is Blue Cross Blue Shield, was holding somewhere in the neighborhood of, I think, $70,000 that was due to the debtor. And the creditor's attorney still refused to release the garnishments or dissolve them. And so there was a motion to dissolve those garnishments filed in the bankruptcy court. The creditor's attorney appeared. This was not a close call. The bankruptcy judge said, you need to dissolve these garnishments, and we're going to come back for a status conference 2 weeks later. Well, not only did the creditor's attorney not dissolve the garnishments, but he initiated post-judgment discovery with respect to some third parties, trying to set up some debtor exams. So 2 weeks later, he showed up and had not dissolved the garnishments. The court was not happy and held that there was I'm sorry, I'm getting ahead of myself. As the creditor violated the automatic stay. This is not a hard one. Yes, absolutely. The court said that it was willful, and you can have a stay violation that's not willful, and courts will tend to not throw the book at you. When you do things like this, you're in trouble. The court did not render a final judgment against the creditor, but set it for trial to determine damages. And it indicated that the minimum damages that were going to be assessed was the amount that was being held by the garnishee, Blue Cross Blue Shield, which was in the neighborhood of $70,000. So that was the starting point. So key takeaways: do what the bankruptcy court tells you, and when in doubt, when the automatic stay is in place, always assume that any action you do is an action to collect, unless you're pretty confident that it falls in one of the exceptions.
Yeah, don't mess around with judges. You're almost always going to lose, right? Especially in bankruptcy court, when you're thumbing your nose at a judge's authority, they'll come down on you hard, let you know who's boss. All right, number 13, Chris. I think this is yours as well.
This is also mine. Yes. Another note case: can a lender be a holder of a negotiable instrument? When a lender's agent holds the note on behalf of the lender. And this was in Ohio, a case called Deutsche Bank v. Tallier. And Ohio, like Kansas, is a judicial foreclosure state. So, and in this particular case, Bank of America was a document custodian for Deutsche Bank, the lender, and was holding the note at the time that the default notices were sent out, and also at the time the lawsuit for judicial foreclosure was filed. Yes, you can be a holder if it is through an agent, as long as there's a paper trail. And in this particular case, there was a Bailey letter, which sort of ultimately decided the case, where it identified that Bank of America was holding this particular promissory note, and that it was doing so in a capacity as a document custodian. And this is a very, very cut and dried issue. You can hold things through agents. All entities have employees, which are agents. So the idea that you can't appoint another entity just because it's another bank doesn't hold very much water. But some takeaways on this is creative borrowers will try to throw up anything they can, including issues like this, saying, well, you need to have, your lawyer needs to be holding the original note the minute he signs the foreclosure petition. That theory was shopped all over the United States in the wake of the foreclosure crisis so many years ago now, was roundly rejected. So this is just the kind of the latest in that line of cases.
All right, we're going to really pick up the speed here. We have got to get through 18. We'll do this quick. So what happens if you have a borrower, they transfer monies to a loan servicing bank, but they get the wrong account number, all right? And so they're like, oh, sorry, didn't go in the right account, so we're going to proceed with the foreclosure. Does that argument work? Well, your gut reaction is probably saying no, and your gut reaction is correct. It doesn't work. I'm wording it wrong on this. In this case, the foreclosure was prevented by the defense of payment. So even though the bank messed up, gave the wrong number, I mean, the monies did come in, and so the court is allowing what I'll say substantive justice and saying, hey, you paid it, you're not going to be able to do foreclosure there. So 15, Chris.
So we have a husband and wife file for bankruptcy. You have a mortgage servicer who issues monthly statements and has language in there that's saying, if you are in bankruptcy, and this should be taken for informational purposes only and is not an attempt to collect a debt. You will see this on any mortgage statement of any major servicer. It's a little box at the end. In this particular case, though, there was a line item that was separate from the regular principal and interest payment that was required to be paid, to continue to be paid during the bankruptcy. And the debtors were continuing to make their regular mortgage payment. And that was a $950 charge for attorney's fees. And the debtors claimed that this was a violation of the automatic stay. Was it? Yes, it was. And the big reason that this was a violation of the stay is because the court took a look and said, no reasonable person would take a look at this and think that that charge was a normal part of the required payment under the loan. You sequestered it, you put it in a separate box. A reasonable person looking at this would think they had to pay it now, and that it wasn't, in fact, a demand for payment, and all the weasel language will not get you out of that. So this is not to say you can't issue statements to a borrower in bankruptcy, but you need to be very careful about how they are worded and set up, because simply saying, oh, this is just for informational purposes if you're in bankruptcy and is not an act to collect a debt will not always save you.
Yeah, especially if you're in the consumer context. I think that's where you're going to get more dinged on something like that. In the commercial context, I don't know, my experience is people are a little bit more forgiving. But anyway,
true.
Next item, the basic question right here is your borrower files for bankruptcy. They get a discharge, meaning there's no in personam obligation. They don't owe it personally, but it's secured by a mortgage on the house. And the question is, does that discharge somehow mess up your statute of limitations such that the loan cannot be pursued? Good question. That case came out of Colorado, and the Colorado Supreme Court just a couple months ago ruled in the bank's favor, saying, hey, the discharge did not start the running of the statute of limitations clock for foreclosing on the collateral of the debt. And so the lender prevails right here. I think the moral of this story is, especially when you get into a debtor that's in bankruptcy, you need to look at when you've accelerated the debt. You need to see what the plan treatment is, and just be really cognizant that you can't always just sit back and do nothing and hope to later prevail in foreclosing on your lien. Again, it's very, very fact specific. Chris, I think this is your last one, and then I'll round it out.
So this is a valuation fight in the bankruptcy context. There were two competing expert appraisers. One valued this private golf club at $8 million, the other at just over $4 million. And the bank, with its appraiser, apparently assumed that the bankruptcy judge would not closely scrutinize their appraisal. And that was a mistake. How does the final result play out? Very poorly. The judge wholly rejects it. And the judge made several notations that any appraisal has to be, quote, anchored in reality. And this particular appraisal, the high appraisal that was thrown out, assumed that significant deferred maintenance had already taken place when in fact it had not taken place. They also assumed that because this deferred maintenance would take place, that the number of members, paying members, would be static, or roughly static as it had been. But the court pointed out that based on that appraiser's own testimony and the opposing appraiser's testimony, that when you go to do deferred maintenance, you have to make assessments, and members don't like paying assessments, and members will leave if they get assessed a certain amount. And this was the Jenga piece that got pulled out, and the whole thing collapsed. And the court basically said this appraiser had completely lost credibility because his analysis was, quote, not anchored in reality. So don't ever assume that bankruptcy judges will not go through these things pretty closely and scrutinize them closely, because this is what they do. You might be able to get that past some folks, but the bankruptcy judges, no way.
Yeah, right. So just because your appraisal sailed through loan committee without any problems, right, doesn't mean it's going to sail through the public's view without problems. And I know I've had over the years when I'm talking to special asset officers, I've had various special asset officers over the years kind of make these comments about the in-house valuations that are going on, and they'll sometimes really question it or say, why on earth did we do this, right? And maybe that's why you're dealing with a bad loan. There was maybe just a human error, but we need to be really careful about what we're basing this on. The last one, this is actually kind of a boring one. It comes out of Puerto Rico, but the moral of this story is really focusing on the language of your security agreement. And down there, the lender had a perfected security agreement in the borrower's milk quota, and the borrower filed for bankruptcy. Lenders saying, hey, the future milk sales and quota, they are subject to my lien, and the court rules in favor of the debtor, rules against the lender, because the court said, hey, the wording of your security agreement was just limited to the milk quota and the pre-petition AR. Now, I realize none of you are down in Puerto Rico. We're not dealing with milk quotas, and they have a unique system down there. But the moral of this story, the key point, is that sometimes we have poorly worded security agreements. We think we're good, and then bankruptcy, it's like shining a light, and then you see the cockroaches just run. You go, oh my goodness, we have a problem. And that's what a bankruptcy will do. It'll shine light on your security agreement in a way that you suddenly realize, oh my goodness, we drafted this really poorly. What do you do in those situations? Obviously, you're going to find out, a lot of times you'll find out about that in a forbearance situation. And so that might be the time to quietly kind of clean up the loan documents, expand, get a more expansive definition, and then pray that you get past your 90-day preference period. So that actually covers the quizzes for today. I think we haven't had any other questions come in. We do want to thank you for attending today. Again, this program was approved for continuing legal education hours, and if you want to report it, you click on the CEU icon at the bottom of the screen. A certificate of attendance will be emailed to you tomorrow, along with the recording of the webcast, so you can watch and share. I'll say this parenthetically, I am planning to do these. We'll have 2 more of these this year, one in, I think it's September, and then the last one will be in early December. Same format, but we're going to be talking about just the latest, cases and what's the practical application for you. So the final point is we do have the survey. If you don't mind, please take 30 seconds, fill it out. We really appreciate any comments or feedback that you may have. And with that concludes our webinar for today.